It's great to be here at the Bay Area Book Festival, and we are here to talk about an amazing, terrific new book, Hiding in Plain Sight, The Pursuit of War Criminals from Nuremberg to the War on Terror. The book tells the story of the global effort to apprehend the world's most wanted fugitives, beginning with the flight of tens of thousands of Nazi war criminals and their collaborators after World War II. The book moves on to the question of justice following the recent Balkan Wars and the Rwandan genocide, and ends with the establishment of the International Criminal Court, the ICC, and significantly and importantly, at the end, also America's very different approach to justice after the 9/11 terrorist attacks. It's a story fraught with broken promises, backroom politics, ethical dilemmas, and daring escapades, and I would add, state-sanctioned murder, all in the name of justice and human rights. It is a pleasure to see all of you again. I'm going to introduce, starting to my left, Victor Peskin is an assistant professor at Arizona State University's School of Global Studies. His research and teaching interests lie at the intersection of international relations, comparative politics, and human rights. Victor has spent a lot of time looking at various tribunals. He's also the author of International Justice in Rwanda and the Balkans, Virtual Trials and the Struggle for State Cooperation. Welcome, Victor. Alexa Koenig is the executive director of the Human Rights Center at UC Berkeley and a lecturer in residence at UC Berkeley School of Law. Prior to her appointment at Berkeley Law, Alexa served as program manager of the Witness to Guantanamo project, and we'll be hearing a little bit about Guantanamo. She is currently a member of the Technology Advisory Board of the Office of the Prosecutor at the International Criminal Court, and is often called upon to speak about the role of emerging technologies in human rights practice. And Eric Stover on the end is faculty director of the Human Rights Center and adjunct professor of law and public health at UC Berkeley. During the wars in Croatia and Bosnia, Eric served on several medical legal investigations for the International Criminal Tribunal for the former Yugoslavia. And earlier than that, in the 1990s, he conducted the first research on social and medical consequences of landmines in Cambodia and other post-war countries. His research helped launch the international campaign to ban landmines, which received the Nobel Prize in 1997. Eric has written a number of books. The most recent before this one looks at witnesses. It's called The Witnesses, War Crimes, and Promise of Justice in The Hague. So it's great to have you here. I want to start out with just one of the great things about this book is how these different eras in history, these different tribunals, these different strategies and efforts to capture, apprehend war criminals are connected thematically. And I think that's one of the really effective things of the book. I want to ask you how you developed the concept for the book and perhaps how it aligns with the mission of the Human Rights Center.
That's mine. Okay. You're going to see this quite a bit. We're going to keep handing off one to another. Well, the Human Rights Center has been here at UC Berkeley for 20 years now, and our focus has been on using science, medical, forensic sciences in particular, now technology, new technology advances, to investigate war crimes around the world. And also to make sure that when these investigations take place and when programs are put in place in post-war societies, that there's care for the victims who suffer. So for example, victims who are asked to go and testify at an international tribunal, are they given proper protections? Are they given proper psychosocial services and so on? So we focus on people, and we do empirical research. We have done, in northern Uganda, where the Lord's Resistance Army has been operating for years, we did 3 country surveys to find out what people thought about justice, and also helped set up a girls' academy there for young women who came out from the Lord's Resistance Army who had been sex slaves to the commanders and had children, and they weren't able to get education, so we helped establish a special school there. So the way it ties to the book is most of the center is focusing on victims and and investigations. But what also became clear is ever since the establishment of the modern tribunals, which would be in 1993 with the Yugoslavia Tribunal, We were fascinated with the question of, these war crime suspects are often on the run for 14, 15 years without being arrested, although all countries in the world are supposed to arrest them. One example would be Omar al-Bashir, who was indicted in 2009 by the International Criminal Court, and he has now traveled made 77 trips to some 22 countries around the world. And many of those countries, because they're members of the International Court, should have arrested him. So our question is, what's going on here? So the lens, and I'll sort of close with that, the lens that we used was to try and understand the flight and pursuit of war crime suspects through an operational lens. So that means, how do you actually go after them? How do you detain them? How do you transfer them to a court? Secondly, we wanted to find out the legal. So what's the legal framework in which these courts operate? And thirdly, and probably the most important, is what are the politics of this whole pursuit of war crime suspects? And the theme that really comes out of the book is that you see that that political leaders and states sort of ebb and flow. Sometimes they'll pursue war crime suspects, but then when it doesn't really fit with their security or political needs, they'll pull back.
You call it the vicissitudes of political will.
That's right, yeah.
I want to get into that a little bit more. In terms of the concept of the book, there are lots of books about Nuremberg. There have been some books about the tribunals created in the 90s for events in Yugoslavia and Rwanda. There have been books about the War on Terror. Mm-hmm. You put all of those things in the same book, connecting them, even though it's certainly not a straight line. Mm-hmm. Talk a little bit about the thought process behind including the War on Terror, mm-hmm. which is obviously a very different approach to justice than Nuremberg.
So really there were two reasons that I can think of, and I'm sure my co-authors will have other reasons as well, to include the United States in the post-War on Terror era. First, the role of the United States in enabling so many of these high-level war crimes perpetrators to go free was a common theme that kept recurring. So as we were investigating these stories all the way from World War II through the tribunals, we noticed that the United States was really at the heart of many of those stories. And that was not a tale that's really been told. So the tying together of all of these stories with that common connecting theme was something we thought was important to tease out. The other thing that I think is really important is that in the post-9/11 era, you have, of course, the tragedy that happened with the attack on the World Trade Center, Pentagon, etc. It was the first time in a very long time that the United States has itself experienced that kind of exogenous shock, where it has felt itself that vulnerable. And it was fascinating to watch the shift in policy and the shift in law that started to happen really rapidly in those immediate days afterwards. So one of the things we begin to describe in that last third of the book is how from World War II on, you see the United States helping to build this brand new infrastructure of international criminal law and really pushing this idea that courts are a mechanism by which you can get accountability in the aftermath of conflict. Well, after this date on 9/11, you begin to see a split in the road, where you see the International Criminal Court. It's just come into creation and taking up its practice in 2002. So right after 9/11 has happened. And at the same time, you immediately see a drawing away of the United States government from supporting the International Criminal Court. It had been actively engaged in helping to build the body of laws that established the court in the first place. But suddenly you see everything from the United States entering into agreements with countries to try and get them to sign pieces of paper that said, we will never send a U.S. citizen to the International Criminal Court, and really saying, we won't give you economic support or other political support unless you sign these pieces of paper. So you really see a drawing away. And we talk about how this legal path continues and this fight for International Criminal Court becomes stronger and stronger, but it's in direct tension with what you begin to see happening underground with the United States.
Yeah, I think the inclusion of the War on Terror section kind of completes the story about the pursuit of fugitives. If we only examined the contemporary war crimes tribunals, a lot of the focus would be on the lack of international will to secure arrests of war crimes fugitives. And if you look at the story of the Balkans, a war crimes tribunal, you see the story of the kind of initial failure of will. Moving to the pursuit of terrorists today, the key problem is the kind of overzealous pursuit of suspects outside of a rule of law paradigms and frameworks. So we want to also caution about the failure of a lack of a political will to get arrest, first, and second, the problems with overzealous pursuits which undermine concepts of justice and human rights.
So, Alexa, you mentioned this tension, and I mean, you see it in the early chapters on Nuremberg. I mean, on the one hand, we read the amazing rhetoric of Robert Jackson, yes, the chief prosecutor, and then we read about Nazi scientists being protected, their past being covered up and being brought to the U.S. and other countries. And I was thinking about that in terms of a theme that's developed later, the sort of justice versus security argument, that if you pursue certain war criminals, it's going to destabilize certain countries. There's also I'm wondering whether that also connects with Nuremberg and justice versus security, this idea that, well, the Nazi scientists, they may be bad, but they're going to help us counter the Soviets. And we see these calculations again and again in the book, whether it's security or stability. Talk a little bit about that first in the context of Nuremberg, because, I mean, it is to read again some of these accounts of what the extent the United States went to protect these Nazis who were involved in horrific atrocities. It's once again shocking to read that.
So I'll begin. So I think with Nuremberg and Tokyo, first of all, to be clear, the principles of international criminal law that came out of Nuremberg and Tokyo were extremely important. And I mean, it really ushered in an era of international justice, which during the Cold War got put in the deep freeze, but came back out again in the 1980s with courts established, first of all in Argentina and other countries. So let's be clear, and it was extremely important. But there was an element of selective justice, and you can call it victor's justice or selective justice at Nuremberg itself. One is there was a lot of debate as to whether there'd be the charge of genocide, but the prosecutors, Allied prosecutors in the United States, pulled back on that because if you're bringing charges of genocide, which was just at that point being defined, and genocide was really defined as destroying in whole or part a particular group, then what would we do about the Native American, destruction of Native Americans in the United States? Or what would we do about slavery? And so those charges, that particular charge was not included. Secondly, both at Tokyo and Nuremberg, there was selective indictment, or cases. The bombings of Dresden, the fire bombings by the British and Americans was not included because they didn't want the defense to be argued against or bring those cases up. Of course, Tokyo Tribunal, it's very clear, Nagasaki and Hiroshima, where some 300,000 people were killed. There was also cases in which there was a particular defendant that the Americans, who was an expert on germ warfare, who we wanted to get that information so the Russians wouldn't get it. So a deal was made so he wouldn't be brought to justice. So that's to say there's this sort of little line of sort of hypocrisy at times that runs through this long story. And I think just to loop back to the 9/11 argument, I think if everyone here were to think back to September of 2001 and to think, well, what happened that we didn't know was that on the 17th of September, President Bush had a secret directive called Operation Greystone, in which he authorized the CIA and the military and the FBI to work together to set up black sites around the world, and that detainees who were believed to be terrorist suspects would be taken to those sites. And the whole question was, well, how far can we interrogate them? Because the information, we were afraid another attack was going to happen. It's in their mind, so we need some means of rough interrogation. So all of a sudden we're seeing a distortion of international law, with many statutes and treaties against the use of torture. So this is kind of the theme, at least with the United States, that we keep looking at.
Yes, the conflict between peace and justice, some people speak in terms of a conflict between the interests of peace and the interests of justice, is a major part of our book. We're interested in the politics and the success and failure of pursuits of fugitives. And oftentimes, a diplomat say privately that we want to put pressure on a certain state to hand over a Serbian fugitive, a Sudanese fugitive, but it's not the right time because doing so could undermine a pursuit of a ceasefire, a peace treaty, or something like that. So the peace kind of argument is a very a powerful argument sometimes. It talks about the importance of compromising the pursuit of justice, delaying it in order to stop that kind of a situation on the ground, improving it on the ground. And so in certain situations, empirically, that might be correct, right? And so the spirit of our book is to investigate the debate over the conditions under which pursuing indictments and arrests might foster peace on the one hand or undermine it. And so in certain situations, in the short term, it may make the quest for a ceasefire trying, except for in the long term, usually, probably pursuing justice helps peace.
Yeah, in fact, in the book, there's a very good example. You run through the situation in Uganda with Joseph Koenig and the concerns of groups in Uganda about the efforts to capture him, and it might destabilize peace negotiations. But ultimately, it doesn't play out that way. I want to go back. So Nuremberg sort of goes into the deep freeze in terms of this approach with the Cold War. The Cold War is winding down. We're in the early 1990s. Yugoslavia is falling apart. There's terrible atrocities. I was actually a young reporter covering some of that. And this new tribunal gets created, but it doesn't have the same powers as Nuremberg had because, Western armies were not occupying former Yugoslavia. In fact, the war is still going on with a pretty weak UN peacekeeping force there. So talk a little bit about this approach to this new tribunal, which is not trying to be victor's justice. It's trying to, hold everyone responsible in a pretty complicated civil war.
Yeah. So we go back to late 1995 and the signing of the Dayton Peace Accord. So the political leaders of Bosnia and Serbia come together, and it's decided there'll be a peace accord. And in January, we send in S4 troops, NATO troops, and American troops are there. There were some 80,000, 60,000 troops who flood into Bosnia. To sort of give an idea of the scene at the time, at that point, I was working with forensic scientists to do the exhumations of mass graves throughout the country. We were doing this on behalf of the Yugoslavia Tribunal, and we were investigating the Srebrenica massacre of some 8,000 Muslim men and boys. And it was a pretty extensive investigation, and we needed protection for our forensic teams. These were forensic scientists coming in from all over the world. And it was a dangerous situation. And we went to NATO and we asked, could we have American or British or French troops to guard us? And nobody wanted to do it because they were fearful of mission creep. And the reason for that is really on the part of the United States was that 3 years earlier, we had the Black Hawk Down incident in Mogadishu. And there was a real sort of reserve against getting troops engaged in making these arrests or for protecting mass graves. Eventually that changed. But the interesting thing was, at that time, the checkpoints that were set up by NATO troops, Radovan Karadzic and Ratko Mladic, the two top Bosnian Serb leaders just passed through these checkpoints, and everybody, they turned their backs and let them go through. That eventually changed on the part, and this is a kind of second theme, the ebb and flow, and the second theme of the book is the role of individuals. And we really credit Louise Arbour, who is the chief prosecutor at the Yugoslavia Tribunal. She's a Canadian judge. And she decided, wait a minute, we're not going to issue public indictments, of which there were many had been issued. We're going to issue sealed indictments. And NATO liked this, because what NATO really feared was the fact if you have a suspect who knows he has or she has been indicted, they have bodyguards and they have their own paramilitary, that there could be a shootout. It could be a rough encounter, and you don't want your soldiers in that situation. So by a sealed indictment means the court has indicted this person, but you don't make it public. And the minute that that happened, NATO sort of realized we weren't going to have World War III in Bosnia, and they started making arrests. And over the next 5 or 6 years, 6 special forces from 6 countries came into Bosnia to help with the whole arrest operation.
And just to add, a reminder that Srebrenica was a UN-protected safe zone with UN peacekeepers, Dutch peacekeepers present when the Bosnian Serb army took control, and that led to the slaughter of these young men and boys. And that added another wrinkle in terms of UN accountability in some of these situations. Another thing you talk about, obviously these tribunals are created to prosecute the senior-most people responsible for these crimes.